also, the respondent shall fully compensate the claimant for its costs and expenses in this amount, $4.2 million. And that's the whole point of the decision. Let me go. And can you see the bottom of the slide? I'm having
Yeah,
a
yeah, we can see it. Yeah.
okay. So the costs were 4.2 million, 4.005 million as well. And on the overall, if you look at it from the perspective of a relative comparison, the overall costs were about slightly over $8 million. When we look at the breakdown, then we have the exit fees and expenses, which would include the arbitrator's fees as well. And then the lawyer's fees for the witnesses and the expenses related to the overall effort as well. So not only the quantum, but occasionally the costs are important in this context too. And this based on what the tribunal decided, this appears to have been a well-written award with the reasoning and everything else of that sort. But what about if the things fail? And last night I was reading a brief note about an exit case which was dismissed. This is a case, I just have it on my iPad. This is exit case number 24/45. The claimant is Nurhima Kiram Fornan, and the respondent is the Kingdom of Spain. And the award, which was dated November 6, 2025, that's 2 or 3 weeks ago. It is just one paragraph of the award, the decision in the substantive part. I am looking at the translation from Spanish to English, so I will read the English part. For the foregoing reasons, the court decides as follows. Claims brought to your attention under this arbitration are manifestly without legal merit and are dismissed pursuant to Exit Arbitration Rule 41. Claimants shall pay the respondent for the latter's share of the tribunal's fees and expenses and exit administrative costs. Plaintiffs shall pay defendant for the cost of defendant's legal representation, and the defendant's claim for interest is rejected. So sometimes if the case does not have any merit, the arbitrators, they are smart people and they can assess the situation, the dispute for which they have a claim on their plates, and then they can make the proper decision in that regard. So it's all coming down to, again, the merits, and then what are the damages? What are the amounts that would be of interest for the claimant, and then all the others involved in the whole process. Now, this is a little bit about the third-party funding and the Islamic Sharia. I'll just make an introduction to a few of the principles, but I will not spend more time on it. And here, as we already talked about it yesterday, I will talk about Gharar, and maybe I will show only one slide from the latter parts about riba interest issues. And even though it is not immediately part of today's material, I really would like to make an introduction at least to the quantum of damages. So, What are we seeing in the Islamic Sharia context of the third-party funding? It is appealing as a concept. Third-party funding is appealing in jurisdictions under the Sharia law. And of course, we all know about the sources of legal authority under the Sharia law as well. First and foremost, there's always Quran, and it is the principal source of the Sharia, followed by Sunnah, the traditions, the Prophet Muhammad's traditions, deeds, and sayings, and they only supplement Quran by the interpretations, clarifications, and of course, complementing the principles in the Quran as well. And it is typically compiled in all those collections of the traditions, hadith, or as we say in Turkish, the hadith or hadith sharif. And of course, we have the secondary sources as well for the community ijma, for community consensus, qiyas, that's the comparison, analogical reasoning, ijtihad, and urf as well. There's a reason I talked about the common law principles and the Sharia as well. In addition to the requirements of good faith, dealing with good faith requirements, we also have the other ingredients of the formation of a contract as well under both common law jurisprudence and the Sharia law as well. The the parties have the capacity to enter into a contract. They enter into the contract willingly. They have the chance to determine the terms of the contract and also the scope, the subject matter of the contract as well. And there's a reason I wanted to fast forward a little bit into this information too. The contractual limitations under Sharia are also relevant from the enforcement point of view too. As again, I was discussing it earlier today with our Secretary General, the award is a meaningless piece of paper if it cannot be enforced. It's just a piece of paper with some reasoning and some numbers on it. And of course, from a risk or speculation or uncertainty point of view, we have those two concepts which might be grounds for failure to recognize and enforce a an arbitral decision, an award, given that we might be violating the principles of public policy in the jurisdiction where the awards will be enforced. First is riba. I know that there's all that discussion about is interest riba or is it not? Now, from an Islamic financial transactions perspective, there is no room for fixed interest rates. And the definition of riba, as far as I understand, is related to an increase or an excess or surplus, but it is more of a sure return, that kind of an increase without any risk taking. And for those of you who also have exposure to the financial theory, there is the explanation of the nominal interest rates and the real interest rates. The nominal interest rate in the financial theory has two parts. There is the time value of the money, which is to make up for the inflation, plus if there's anything else, that's the real interest rate, which is the excess rate that is earned on top of the inflationary compensation. There's a reason I'm mentioning these topics at this point, because when I come to the riba decisions hopefully next month's workshop, there will be different decisions from different jurisdictions under Sharia law who look at the compensation for the time value of money just for inflation without excess compensation. So that distinction is quite important in that context as well. And from our perspective, when we look at riba, it is that sure return without any risk taking. And it is compared to the usury in common law, and that's the whole foundation for riba being one of the violations of the Sharia law, which might result in the failure to recognize and enforce an award in a jurisdiction for its enforcement. Even though I said more later here, I'm going to go to one slide from next month's materials, and this is about the user interpretations in third-party funding arrangements. So let me be clear about riba as I was talking about it. To let me go back and oops. If we talk about interest rates or riba in this context, we might encounter it in three different places. The first one might be the between the third party funder and the claimant who gets funded. The second one, which I will delve into in great detail, is about the calculation of the quantum of the damages using the discounted cash flow, the income method. And the third one is in the concepts of prejudgment interest and the post-judgment interest. Here, the example I give is about that first part, the nature of the funding arrangement between the third-party funder and the funded claimant party. So, occasionally, those third-party funding agreements can be viewed as usurious. So they are excessive in terms of charging the interest rate. And some case law uh, held that if the underlying third-party funding agreement about that dispute, where the third-party funder provides the finances to have that dispute resolved, if the risk of that dispute resolution mechanism is so low and the outcome is almost certain, then the third party funding agreement is not something that we have seen that I have described yesterday. It's not a win or a lose or something in between, like a settlement or alternative to. If it is too certain in terms of what the outcome is, then it is not a funding agreement in the traditional third-party funding sense, but it's more like a loan with the repayment obligation. It is a certain payment with no chance of what is called as a default in the traditional credit sense. And if there's that kind of uncertainty, then the underlying third-party funding agreement cannot include a rate which might be higher than the relevant usury laws of the jurisdiction. And then the courts have the choice to have some say on those underlying agreements. They can either annul the agreements or revise them by incorporation of the appropriate rates. In the first case uh, of such example is between Lawsuit Finance LLC and Curry, where the agreement was totally voided. In another example, the agreement was rewritten to comply with the state usury threshold because of those almost certain outcomes associated with the collection of the awards or whatever might be recovered. Now, let me ask everyone, do you see the jurisdictions? These are not Sharia compliant jurisdictions, but the concept applies here also. The
Yeah,
first one is from the Michigan Court of Appeals. The second one is New York State Supreme Court.
yeah,
So they need not be Sharia compliant jurisdictions, but the principles are the same.
yeah.
Dr. Hosseini, let me turn it over to you and I'll take a sip of tea.
Absolutely. That's what I really want you to do. And that's why I want to kind of intervene here. It's quite interesting to note this that these are not Sharia kind of countries or Sharia-based legal systems. But again, you're having this kind of annulment of agreement or revision of those agreement by incorporating the appropriate rates. This is quite interesting. But again, I won't say it's the same thing as Sharia itself or it's the same thing as Islamic law because we may not be able to perfectly equate them. Because here, the usury laws actually have limits in the United States. Different states have their different laws relating to this. So they have limits. So if you go above the limits, then that can lead to an annulment or revision to the
Yep,
appropriate rate. So there is still the usury dimension there. So it's still built into the contract. It's only that, okay, you've got a limit, you've got a cap. In some states, they will say, okay, you cannot charge more than 60%,
yep.
basically. So it's capped. So, yes, this is actually the practice here in terms of the different interpretation of usury, but usury is still allowed. You know, you've got those usury laws in place, but under the Islamic legal system, it's not going to be allowed because it's going to be zero.
Yep.
But it's interesting to see the aspect of annulment, complete annulment. So you cannot just say, okay, let's introduce a blue pencil rule or whatever to just kind of, amend or revise the agreement by incorporating the appropriate rates. And it leads to, so what do you see when there is a complete annulment of the agreement itself? If the agreement becomes void, so the third party funding company does what? Loses everything?
They might lose everything, or if there's that kind of annulment, it might be set at just the recuperation of their investment with no return.
Oh, okay. I
So
got it.
that might be the thing. And of course, that's one point where I would tie it to the other maybe partial annulments as well. And that's a very good point in the sense that, for example, today is Wednesday. 6 days ago, here in New York Arbitration Week, I was talking to Dr. Marianne Caldas. She is the executive director of the Egyptian Center for Arbitration, and she described that in the Egyptian case, a partial annulment is granted if an interest rate of higher than 7% is part of the award. And her point was that the partial annulment of the award is such that it is sent back to the tribunal so that the interest rate would be revised to that maximum of 7%
Okay.
in that context. And I'm thankful to Dr. Mariam for her remarks. Yeah, again, that was only 6 days ago.
Okay, yeah.
Yep.
Okay. Are you okay? Let's think of a situation where it's an Islamic finance agreement or it's an Islamic finance jurisdiction. So can the court actually say, go back to the tribunal to kind of make it zero? So we're talking about zero now rather than just revising to 7%. So that, okay, the whole usury or interest element should be revised to zero. What's your take on that?
Um, Again, it will depend on the circumstances of the arrangement. If it is that kind of a third-party funding arrangement, it would be maybe more like imposing a limit, because looking at certain third-party funding arrangements, especially maybe in the context of mass torts or the insurance claim collections around some torts, the funding is such that typical funding goes to maybe 10 or 12% of the overall face value of the claims. And in that case, they would, which might lead to some excessive returns over 100% or so. And there might be, in that case, just revisions to impose a return limit on what the third party funder provided. We are talking about the first of the places where we see the interest. If we are talking about a zero interest in a discount case, that's music to the ears of the claimants, because then everything will be discounted back to the
Yeah,
present value as their nominal values without any discounting.
yeah. Yeah.
So now let me go back here. And we already talked about Garar as well. That was yesterday. There was a question which was about today's material, but that was great. And here we have not the certainty, but the other extreme, where there's excessive speculation, uncertainty, or excessive risk taking in a transaction or subject matter. In the context of third-party funding, we can take it to be in relation to the overall dispute, the parties, and the fact pattern. And that would all shape the decision of the third-party funder. If the third-party funder acts recklessly and throws the money around, that's excessive speculation. But they do not typically want it because they know that with the nature of the third-party funding arrangement in place, they are very likely to lose, because these arrangements are typically structured as non-recourse loans without any specific interest. And if we look at those two limitations, which might shape the overall enforcement and collection of the awards, we see the whole spectrum, but being in between two endpoints. At one endpoint, no risk taking, some return. At the other extreme, excessive risk taking, some speculation, some gambling taking place. So if we want to put everything in between, where the third party funders may operate, it would again come down to what we talked about yesterday. There's a reason I repeat the first bullet point. Some people may see the third party funding as high risk opportunity because of all those unpredictable outcomes, as well as the overall judicial process as well. And on the other hand, the amount of money that the third party funders can commit to and then spend over the course of the progression of the arbitration, they are quite predictable. As we saw, unless we go for some of those excessive big cases, the cases overall costs are quite manageable collectively for both the claimant and the respondent. And it all comes down to the extent of the uncertainty. It is well calculated risks as a result of the due diligence. And that's why I emphasized yesterday, so do I it now. It's all about the due diligence, due diligence, due diligence. And I read that decision from ICSID. If a case has no legal merits, third-party funder will not fund it. They will not throw their money around because these are non-recourse loans. If it is too certain, then it is unlikely that there will be need for some kind of a third-party funder. And what happens is that, again, repeating to yesterday's material too, the due diligence on the legal merits as well as the quantum are essential. And we went through those statistics yesterday too. Uh, the Government Accountability Office statistics show that about between 1 out of 20 or 1 out of 25 cases are funded based on the evidence collected in the US. That other source mentioned about 1 out of 10 requests are funded after the due diligence. However, there is one point which I feel like I did not stress it enough, and that's my gateway. That will then be my gateway into the quantum of damages calculations as well. Now, if you look at the last part from yesterday's material, the due diligence by third-party funders also entail the retention of quantum experts like myself. Being an arbitrator, I'm a quantum expert too. So, what do the quantum experts do? They will employ the tools which we will start covering in a few minutes' time. But also, what happens is that they, based on the analysis of those quantum experts, the third-party funders, and as part of their due diligence, determine whether the claims are large enough to justify funding the dispute being considered under all the legal due diligence outcomes as well. However, who do you hire? Now, of course, so it will be me promoting myself, but in the
No,
overall process,
no,
you
no,
see
no.
that,
No, you ask me the question, who do
yep,
you hire? I'm gonna hire you.
thank you, thank you. You are very kind, but let's talk about it over the course of the due diligence, which we will then consider to be a funded case. Okay, you hired me to do the due diligence, or you hired somebody else to do the due diligence before funding of the case, because that's the time when the claimant, claimant's counsel share the information with the third-party funders, and they do all that deep analysis before filing the claim, before getting the funding. If you hired me, or if you hired Mr. X, let's talk about the Mr. X, what will you do? Will you hire him as your quantum expert for the arbitration as well? This is a debate which has started quite recently in the consulting space, legal space, and the third-party funding space. For Mr. X, who was hired to do the original due diligence quantum, he is incentivized to come up with a large number so that the case gets funded and then he gets retained afterwards. The other point or the counterpoint is that, hey, why should he do this? Eventually, he knows that he will not be able to defend those numbers in front of the tribunal when he's cross-examined. And now there are there are two different sets of people who say either hire different experts for due diligence versus the actual arbitration versus the other group who just say that let's stick to the same person for cost efficiency purposes and continuity purposes. This is a debate which has just started very recently, and we do not know what the ultimate outcome will be. Let me just go back to where we were. And even though I was saving this for a later part, I think this is a good place to make the introduction into the quantum of damages calculations, principles. That's why I went back to that former slide to talk about the quantum of damages. Okay, I also talked about the breach of contracts and the compensation in the form of torts and claims. And if there is some kind of a alleged wrongdoing as a result of the uh, arbitral process, there will be the compensation to bring the claimant to the point that he or she would be as of the point of that alleged tort or breach of contract taking place. And that place in time, which you saw in that example, in that former example, as of the valuation date, which is when the expropriation took place in that one specific example, the value is important. What do we mean by value? There are all those different definitions of value: fair market value, equitable value, investment value, you name it. And anyone can come up with different definitions of those values. But whenever we are trying to put a number on the valuation methodologies or the approaches, we can always say that they are subject specific or case specific, including the surrounding circumstances of the matter. And the parameters or the concepts we look at are in relation to the basis and the premise of value. Again, including the intended purpose of the valuation as well. Because the valuation professionals, they also do those analysis for reporting purposes, for employee stock of ownership purposes, for any other reporting or decision-making purpose, not necessarily in the legal context, where a number will have to be used for some purpose. And of course, there will be different strengths and weaknesses of each of those valuation methods, and we will look at them afterwards in the coming slide as well. And when we look at the investor state kind of disputes in that kind of space, there are all those different provisions in the bilateral investment treaties or the multilateral investment treaties in regards to the standards of those compensation. And the typical term that's used is fair market value. That's why I chose these two examples. I know lately ECT, Energy Charter Treaty, is not that popular, but just for the sake of disclosure purposes to everyone, for illustrative purposes, Article 13(1)(d) of the ECT states that expropriation should be accompanied by the payment of prompt, adequate, and effective compensation, and that such compensation shall amount to the fair market value of the investment expropriated. So the term here is fair market value. When we look at the Netherlands Model Investment Agreement, from 2019, that's Article 12.5. The compensation referred to shall amount to the fair market value of the investment at the time immediately before the expropriation. The valuation criteria shall include different measures of the value as well, going concern asset and all the others too. If we just more point before I move to the next slide, uh, at the time immediately before the expropriation. Again, in that success example that I showed maybe half an hour ago or so, the valuation date was determined as of the day immediately before the expropriation date as the tribunal decided. So these are just some examples of the measures of value, but let's get into the typical valuation approaches. And these are the three main categories. When I was talking about the working group number three of UNCITRAL for the ISDS reform, I think it was working paper 255, which summarized these three approaches at the very high level too. They did not report anything new for the valuation professionals, at least in the United States. These three approaches are part of IRS ruling 59-60. So they are from 1959. And the International Valuation Standards Council has their guides, which are, I think, published every other year on the odd numbered years. They will talk about these three approaches as well. These are the three main categories of the approaches that we use when we are coming up with the quantum of damages, but these are not cookie cutter methodologies or approaches. Each one has its finer points for the treatment of the specific asset or the contract around which there's a dispute, the industry, oil and gas and mining is different than a construction. You saw the types of the disputes that I covered yesterday, filed by the OIC country claimants, or in finance, they are different, or you name it. Energy is different than mining, you can say. In mining, you have more of a delayed revenue stream. That's pretty much the determinant of the finer points of all those valuation methods, and they are not quite easy as you can appreciate it. It may be that there might be in one case in which I was involved, an exit matter, we looked at the income, the discounted cash flow approach with the monthly projections, that's 12 months a year, times 30 plus years. We had, I think it was 32 or 33 years, so we had quite a high number of close to 400 months cash flow projections in the actual scenario and the but-for scenario. The original projections versus the point in time. And they are not quite easy to come up with. Let me turn it over to you, Dr. Oseni.
Yeah, thank you. I just wanted you to take a break to kind of enjoy your
Thank you.
tea for a while. This slide is extremely important for anybody listening to us today. If you don't know these valuation approaches, you're going to face a lot of problems when you sit as an arbitrator. It's extremely important, and this really come handy when you're writing your award, particularly the dispositive section of your award. So this is something you have to pay attention to. And I would like to humbly ask Dr. Khan to please explain them, break them down as if you're teaching like a primary school or a toddler. Break it down one after the other, and you have like 10 minutes to do this. Then we'll go to Q&A. We do have a number of questions waiting,
Okay.
and I really want to end this webinar at the right time, basically. So please take it one after the other, break it down so that people will learn from this. This is the essence of this webinar itself. Yeah.
Yep. Okay. Thank you. Thank you. For the cost or the asset approach, now we are talking about the cost as the value of the assets are being considered. So, what does it tell you? How can I acquire the cost uh, of those assets as of a certain point in time? So, you can always think of the cost approach in the valuation of the businesses which are really being formed, which are not going concerns yet. And it is really based on the value of the assets. So, what does it mean? We are in the early stages of a project. We have put in some money. We have acquired some assets. Of course, the net of the liabilities without any of those obligations. So we have acquired those assets, but we are not producing income yet. So what would be the replacement value of those assets if we lose them, if they are expropriated or if, God forbid, something happens? So the cost approach is very fundamental in the early stages of a project when the assets are, I will use the term loosely, lost. The market or the comparables approach is when we have a environment or then assessment of the value using the subject company or the subject business or anything of interest, which is at the center of our calculation, being compared to others in the market. So if there are very close or similar businesses, operations, or companies, or even publicly traded uh, companies, their stocks, where we can use some of those ratios, the typical financial ratios, we can use them. Or if a certain transaction has taken place, it is used quite a lot in the mergers and acquisitions too. It can be about either looking at a similar company in the same industry with certain adjustments for the operational efficiency and other aspects, or a transactional method. If a certain transaction, a merger acquisition, or a divestiture took place, that transactional value with some premiums and intangibles, highly valued intangibles attached to it too, then they can provide as the guidelines for us to use the as the driver of our valuation metric. So it is a similar company which is public, for which you can get some information, or a similar transaction that we can associate with the subject of our valuation here. The last one, the discounted cash flow, the income approach, is where we will also have the interest related concerns as well for the discounting purposes. That's what the name implies too. It is a general way of estimating a value when we have some kind of an income generating ability already associated with that company or the project. So we have projected all those income into the future. I gave you the example of that exit case. We have all the cash flow projections on a monthly basis for the coming 30 plus years. But something else happened. And even though we have the original projections, now the actual world is slightly different because of all those other issues. There might be delays, there might be other issues too. So we have two different scenarios, and their differences amount to what we want to, what we wanted to, but we cannot achieve in that context. And these methods are used again based on the circumstances of the project or the contract or the subject company, the industry, its stage of development. And one rule of thumb is that you may not use all three methods in the same analysis, but you have to consider them and then explain why you did not use them. Income method is the most, I would say, favorite one. And this is the last slide I am planning for today. I have a note here too. I said last slide of module two from my perspective. Um, there is an international arbitration damages study which was done by a consultancy about 1.5 years ago, and all the three methods that I just covered, they are used by the claimants and by the respondents, and also considered by the tribunal as well. The most popular one, again, as I told you, from the claimant's perspective, is that it's the income discounted cash flow method. They look at the projections into the future, all the cash flows that are expected to be generated, and they are discounted back to that valuation date. The claimants do not put much of emphasis on the market, either the comparable transaction or comparable company method. And cost or the asset method is the second favorite of the claimants, while there are other contractual or liquidated predetermined damages are used by the claimants as well. From the respondent's perspective, the picture is slightly different. But when I look at what matters the most, that's the tribunal's decision in the awards. Again, the income method, the discount cash flow method is the most popular, followed closely by the cost or the asset method for the early stage investments as well. The statistics, they are very interesting. Again, remember what I said about that success story. Originally, there was a claim of 100, but then the experts put in their damages calculations for the amounts. And if we look at the first claimed amount, what happens is that with respect to that claimed amount, which is where the claimant comes up with a number, the respondents in their typical rebuttals, the damages they calculated are only 10% of the claimant's claimed damages amount. And of course, at the end, it's what the tribunal decides that matters. The tribunal award, on average, uh, amounted to about maybe 40% of the claimant's original amount. However, there's always a problem with the averages. They are averages. We do not see the distribution of those awards with respect to the claimed amount in some kind of maybe spectrum bar charts if you are familiar with them, or in all those pie charts as well. That big table is, I think, very important from my perspective. If we look at the two extremes, if the tribunal awarded nothing with respect to the claimed amount, it is still possible. There might be a decision, but there may not be any damage awarded uh, in line with that decision. It is possible. There might be a harm, but there may not be any damage associated with it. Even though that seems or sounds contradictory to the typical tort discussion. At the other end, it's also possible that in 5.71% of those cases, the tribunal awarded the full claimed amount of the claimant. And again, you can look at or you can consider the example, the success example I gave you. It was the tribunal awarding 100% of that final claimed amount in that case. Or it can be anywhere in between, depending on, again, the circumstances, what the tribunal defines to be the parameters of the quantum decision, or how the damages are calculated in that context, because the tribunal is the fact finder. And it will tell you is that they can fine tune the parameters of that ultimate award decision based on what they have seen over the course of the arbitration process, because they are the fact finders. And that will be the final determinant of the damages that are awarded to the claimant. And that's where I will stop.
Thank you very much, Dr. Khan. This is terrific. I like the data you showed on this slide. It gives you a kind of a true picture, and perhaps it's going to provide a very good guidance to arbitrators, who are thinking of the best method to use. And once they look at the preferred method on the part of the claimant or respondent, they'll say, okay, I'll go for the DCF, because this is mostly favored by the tribunals. So I think this would be very good for even for young arbitrators who like to kind of, assess damages, in some of the cases they're handling. We do have some questions
Yes.
waiting, and I'm just going to start with the first one. The first one is from an anonymous attendee, and it's like four in one. And there's a huge reference to the Singapore International Arbitration Center's rules. And I'm not so sure whether we're going to have a deep dive into specific provisions on TPF, third-party funding of this, but I think you can just answer the questions generally. I'll just read what you have on the screen, basically. The participant is asking that, or he's saying that SIAC 2016 rules doesn't regulate TPF disclosure directly. 2025 SIAC Article 38 dedicated for this. I'm just reading as it is. 2016 SIAC has TPF guidelines of Singapore International Arbitration Center. Now, this is just a general comment made by
Yeah.
the participant. And the first question relating to this is this. Are there any statistics of disclosed TPF agreement? If there are, about what percent is disclosed? Is it true or is it trust? Okay, do we trust the existence of TPF or the whole agreement? I'm trying to rephrase the question for clarity. So I think the main question you have here, question one, is whether there are statistics on disclosed TPF agreement, and if there are, what percentage of those agreements are disclosed?
I do not have such statistics at my fingertips. I
Right.
only have the anecdotal evidence based on what the judges or the tribunals have requested. or order the parties to provide. But I do not have the such statistics at my fingertips.
Sure, yeah, I think it's very difficult. I mean, we'll need an academic research to kind of get those statistics.
Yep.
Okay, great. The participant has another question, and this is quite good. Or she says, can we say non-disclosure in TPF is healthier since the arbitration community is small, and if we enforce disclosures, there will be always conflict of interest after a certain point, just like the merits and demerits you explained yesterday of third-party funding. And I think she's talking about, he or she is talking about non-disclosure, whether it's healthier not to disclose at all because it's small. If you disclose, then at the end of the day, there's a way that you're gonna connect maybe the third party funder and one of the parties. So at some point you have this conflict of interest. So at the end of the day, that defeats the whole purpose of arbitration. So do you think it's healthy to kind of avoid disclosing?
I would not agree with that because if the disclosure is requested, or if it is ordered by the judges or the tribunals, then we will comply with it. And from the security of the costs perspective too, I think it's important. This is my arbitrator side speaking too, for the overall effort to be at least on solid grounds, at least the disclosure of the presence, and again, we do not say what we are disclosing, at least the disclosure of the presence, and if so, some kind of a security for the costs would be essential. So non-disclosure is something that I would not really come close to.
Yeah, I think that actually dovetails well with my position on TPF generally. And I'll voice this out in different forums, I'll prefer disclosure, but not going into the meat of the whole thing, not
Yeah.
going into the details here. You don't have to open the agreement. The only thing is just disclose that there's an existence, there's an agreement, and the so-so person is behind the agreement. Halas, once you close it there, don't ask me how many percentage of the total
Yep.
claim, if successful, will go to. No, don't go into that. That was a discussion we are having yesterday, which I mentioned about my interaction with the Uncitral Commission regarding this issue. The draft provision is still being debated in the working group 3 of Uncitral. Now, the next question says, and I think it's a follow-up question again. An arbitrator wouldn't know if he is associated in any ways with the funder if the identity and the agreement of the third party funder is not disclosed. Is it correct?
Um, if it is not disclosed, then they would not know. And I know, at least in the past, there were instances when the experts and arbitrators were not notified about the specific identity of the third-party funders because it has got nothing to do with them. And it would not impact their impartiality too, their independence and impartiality as well, because there are different parameters or different frames that we have to draw around the scope of their responsibilities and the third party funding arrangements and the identities of the funders. And from my perspective, it has got nothing to do with me as an expert or as an arbitrator. It has got nothing to do with the
Okay.
scope of what's on my plate. And I think what we read from that judge's decision, that foot uh, note is quite
Yeah.
striking in that regard. It is all about them funding, the third party funder funding the claimant or the plaintiff, and that's it. And
Okay.
whether it will be for or against is irrelevant because they do not touch on the scope of their work, including independence and impartiality.
They're absolutely here. And now let's go to your issues relating to assessment of quantum of damages. This is really an interesting part, and the screen the slide you have on the screen, I think is quite helpful for this next question. The question says, in cases where expert reports on the quantum of damages conflict, as we saw earlier in one of the cases you shared with us, when you have different positions being adduced by the different experts, what factors guide the tribunal's decision making? Have you experienced situations where, after hearing the parties' experts, the tribunal appointed its own expert to resolve the divergence?
Okay, this will be first the legal person in me. Everything will be case specific. Even for similar projects or similar companies in the center of disputes, there might be different choices made by the tribunals for the method or how the same method is applied to. The cash flow projections may differ. So I will jump the gun. This is really from the December materials. It is about the forecasting or assessment of the cash flows over time. It is not just
Yeah.
one cash flow. It is you build a full income statement on a periodic basis, and then the discount rate, all the parameters of these finer points of the cash flows and the discount rate in a DCF approach. Or if we are talking about the others, let me go up. The choice of the transactions, comparable transactions, or comparable companies in the market approach, or in the cost approach, whether there will be additional considerations for some secondary liabilities or contingent liabilities. They would all be case specific.
Yeah.
And based on the claimants versus the respondents, experts, they will have their own views on what those parameters that will feed into the valuation will be. So eventually, coming to the point, the at in instances too, as a quantum expert, we were told that these are our decisions in construction delay cases. Okay, it was what you did was this much, what you did was this much. Claimant, respondent. Okay, we have apportioned the liability. Now do your calculations based on this. And if there is still disagreement, before appointing the independent third expert, we may be instructed to join a hot tubbing session. It's not the physical hot tubbing, but proverbially we are put in a hot tub so that we can put all of our analysis together, put the points where we agree, and then where we can disagree or where we have disagreed. And then the tribunal can make up their minds about which one to use, somewhere in the middle, or to appoint their own experts as well. And I know hot tubbing as a definition sounds interesting, but it is just the bringing of the experts together so that they can identify where they agree and where they disagree. You're on mute.
Sorry, hot tubbing is a very good way to kind of reconcile the experts' reports. And I think in such situations, particularly in international arbitration, it's good to kind of get them together and get them to use the same valuation method. And I
Yeah.
think with that, you're kind of bringing them together towards convergence. Yeah, but again, if they don't agree, like you rightly said, the tribunal can still consider, appointing its own expert. But again,
Yep,
cost issues, we have to consider those
yep.
aspects. Great. I have some follow-up questions. Give me a second. Okay.
Question.
Now, the next question says, when assessing quantum in international arbitration, how can tribunals balance the need for rigorous economic analysis with the practical constraints of time, costs, and differing methodologies presented by parties experts?
Okay, whether we now, this is not my damages expert side. This is my arbitrator side. It is one full ingredient of the overall decision-making process. We look at the jurisdiction, then we look at the liability, then the quantum of the damages, and then the award, and then the enforcement, or if there's any challenge, some annulment too. Uh, I would not economize on any part of the quantum determination in the whole international arbitration space. There might be some original claim amounts, but the determination of the damages, the quantum of damages, is equally important as the liability, because the liability determines the damages, and that's why the claimant filed for arbitration in the first place too. And if we look at some of those examples of the costs, I see that it is not so different in terms of where an expert's or the group of experts value that sits with respect to the legal counsel as well. Legal counsel argue for the merits. The quantum experts, they present their analysis for the amount of the compensation that should be provided. And because the overall arbitration process goes in parallel, even before the filing of the claim, I would not economize on the timing because they go in parallel. And the costs, I think, are really in relatively smaller terms with respect to what we have, even in this illustrative example too. I
Okay,
There is
great.
this, so the experts fees about 625 out of 4. I cannot see the number. My apologies. Let me make it smaller. Yeah, I can see it on my screen. Compared to the legal fees, you can see that
Yeah,
maybe the expert fees are about 1/5 of the legal fees.
absolutely. Yeah. Okay.
Based on just one anecdotal example. Again, this is not one statistic, but it's just anecdotal example.
Yeah. Okay. Just have a question for you here from Hakan Ali. He's saying, since third-party funding is business, what is the only one recommendation to the participants here today that will work in the real world? It's business, yeah.
It is a business. I mean, these are professionals, as you saw from some of the other slides too. They are, I'm not saying that go out and set up a business, but these are professionals and there are publicly traded firms. And they
Yeah.
come from the industry in the sense that the third party funders, the publicly traded ones, the privately held ones, they are seasoned professionals in this area. Uh, and they come from the industry. If Hakan is thinking about some advice to go into the business, I'm not a third party funder. I
Mhm.
cannot really talk about how they got into business. I know
Yeah,
that they are part of the overall landscape,
yeah,
and more of them, as I see them in conferences or so, most of them used to be litigators or who went into this field where they saw the need
yeah,
for the claimants with the meritorious claims. So they used to be practicing attorneys who were litigators and then who moved into this field with their expertise.
yeah,
That's my
absolutely.
observation. Not an
Thank you for
advice, but
that.
observation.
Yeah, that's my we have just about 6 more minutes to end this webinar.
Yep.
This is a special webinar, for ADR week. And I have one last question for you, and this relates to the Sharia part you discussed earlier regarding third-party funding.
Yep.
Now, in international arbitration, how should tribunals and parties address the challenges posed by non-Sharia compliant elements, which you have discussed earlier? I mean, you have in third-party funding agreements. And what practical approaches have you seen to reconcile these issues?
Okay. I would say that based on some of the examples that I have selected for the future presentation next month too, it's for the Sharia compliance perspective, they come mostly from the interest side. And it's about whether interest can be imposed in the form of additional damages, i.e., penalties, what the appropriate interest rate is, if any. Is it compensation for the lost value of time? That's inflation. That's the loss of purchasing power, or is it extra return? So these are the issues that I have seen specifically from Sharia compliance perspective under the riba concept. And it is coming down to the again the specifics, familiarity with where the award might be recognized and then try to be enforced. And that might be increased familiarity with the laws as well as case law. Because if you recall, I showed a bunch of case law yesterday,
Yeah,
and we have not touched on some of the case law, at least up until now, but there are also lots and lots of ICC decisions or other decisions coming from the Iran oil arbitrations, Iran US arbitrations over time as well, and some other case law, which you and I discussed a few
yeah,
weeks ago, coming from Dubai Court of Cassation, Qatar Court of Cassation,
yeah,
and MSAC, the Malaysia Sharia Advisory Council's TAWITs
yeah,
uh, that are there. So it's the familiarity,
yeah.
at least some familiarity on the arbitrator side about the concepts, but again in relation to where the award would be recognized and then enforced, likely recognized and enforced in terms of location.
Yeah. Absolutely, yeah. Thank you very much, Dr. Ozgur Khan. For those of you who are just joining us, we've been discussing, assessment of quantum of damages in international arbitration. We've been discussing third-party funding agreements, and it's been a pleasure to have Dr. Ozgur. This is the second part of the special webinar. We started yesterday, and we're ending it now, but it's not ended yet. We are going to have a physical workshop on this, hands-on workshop led by Dr. Osgar Khan in December, which will get a date for you later. Watch this space, follow us on LinkedIn, you'll get a date from us. and we're going to have this fiscal workshop towards the end of December here in Istanbul, and he'll be leading that, and we'll be going deep into all these points he has discussed. And I'd like to once again thank Dr. Uzgor. Dr. Uzgor is a vice president in financial markets practice at Charles River Associates in New York, and he's joining us from New York. He joined us at 6 a.m. this morning, New York time.
Thank
And
you.
for those of you who do not know, he's a distinguished testifying and consulting expert in liability and quantum of damages and a qualified arbitrator. We are privileged to have him for these 2 days, and thank you so much for joining us. I thank you, the participants, for being with us today. And as you all know, we'll continue with our ADR week. Tomorrow, we'll be having the Global Arbitration Review ISDS workshop, and it's going to be a whole day program. This morning, I didn't tell you earlier, we had the high-level roundtable on mediation, and it was really, really great. We've got representatives from all over the world. The leading international mediators were here. We had a full house, and we're coming up with a policy paper for the OIC member countries on how to guide them to kind of ratify the Singapore Convention on Mediation and addressing the concerns of member states. Now, for tomorrow, we'll be having the ISDS workshop focused on investor-state disputes. And on Friday, we'll be having in the morning a closed-door session amongst the OIC arbitration centers. Many of them have arrived already. They were here this morning in our office. So that will be closed-door session in the morning. And this is the first of its kind coming together under the same roof and forming what we're going to call the Federation of OIC Arbitration Centers. This will be a formalization to be established after the meeting on Friday morning. And after that closed door meeting, we'll be having an open session, which is meant for the public, where Professor Mohammed Abdul Wahab, the global chair, the global president of the Chartered Institute of Arbitrators, will be delivering a keynote speech. And after the keynote speech, we'll be having a panel session to be chaired by Dr. Imad Hussein, and we'll be having members of the panel from different arbitration centers across the OIC region. Many of them have arrived already, and we are really excited to have that. And of course, we're going to end the day on Friday with a cruise dinner. We've secured a cruise, but you're missing Dr. Uzgur Khan. Yeah, we have been having a cruise dinner here with the participants who have registered, and to end the whole week long of events. Dr. Uzgur, any final word?
Thank you very much for inviting me as a speaker, and I'm glad I had so many wonderful questions. And thanks for everybody's participation.
Thank you too. Thank you too. And thank you to all the participants, and hope to see you in our future programs. In December, of course, we're going to have our virtual webinar as well. So stay tuned. Follow us on Twitter, on LinkedIn. I think our Twitter account will be live soon, but we're on LinkedIn at the moment. Check our website for latest updates, and we hope to see you again soon. Thank you so much. Assalamu alaikum.